In takeovers, there is one terminology called shark repellents. Do you want to know more about shark repellents? Stay till the end of this video. Before even getting into the video, please subscribe to our channel and press the bell icon for the latest notification from our channel. So what are shark repellents? Before even getting into shark repellents, let us try to understand what is takeovers. Acquisitions will be done in the form of takeover of another entities. Generally, like if I want to acquire control over another entity, I will be interested in subscribing to more than 50% of the share capital of a particular company. If I am able to acquire more than 50% of the share capital of a company, then definitely I will become the majority shareholder and then I will have a very right and control over that entity. If an entity wants to get into takeover of another entity, the terminology which is used here is the person who is showing interest, he will be called as acquirer, and the company where he is showing interest, it will be called as the target company. So an acquirer is willing to take over the business of the target company. There are certain compliances and law which is required to be followed, which is related to the takeover regulations. It is depending on which type of company you are into. The company will be either a private limited company or a public limited company or even a listed public limited company. If it is a listed public limited company, then you have a separate law which is called SEBI Substantial Acquisition of Shares and Takeover Regulations, which will come into picture. Whereas in case of other entities, that is in case of private limited companies and unlisted public companies, the provisions relating to SEBI Substantial Acquisition of Shares and Takeover Regulations will not be applicable. So what we need to do? There are two important things we need to look at. Whether all takeovers are going to happen friendly? Necessarily not. There are two types of takeovers we generally call. It is called friendly takeovers and hostile takeovers. Please note the shark repellents are laws or the amendments in the main constitutional documents of the company. They are called Memorandum of Associations and Articles of Associations, wherein we will bring in some of the important amendments to ensure that nobody will come over and hostile takeover is not going to happen in my company. That is the basic objective of shark repellents. So if you look at, in case of public listed companies, the SEBI takeover regulations will take care. But in other cases, if I have to look at in constitutional way, in friendly takeovers, there will not be any issue because the company would have already entered into an agreement, and then according to that particular agreement, the people will be coming forward and transferring the shares so that I will become the majority shareholder in the company. But in other cases where without my knowledge, there is a possibility that some people may become the majority shareholder in the company. Yes, of course, the possibility is not there in case of a private limited company because for transfer of shares, approval of the board of directors is necessary. Whereas in case of listed public companies, shares are freely transferable. They can go to the stock exchanges and then they can go ahead and then buy the shares, and then the persons acting in concert, that means who want to become the majority shareholders in the company, they can start accumulating the shares. To ensure that all these things are not going to happen, we can amend the articles of association in a company to include the amendments. They are called as shark repellents. So let me give you an examples of what are the amendments which can be called as shark repellents. One of the important tool in articles of association is to ensure that there are some reserved matters, or we call it as supermajority, or the decisions which is basically taken with the supermajority concept. What is the supermajority concept? Say there is a promoter group or investor group in the company where some decision should not be taken which will adversely affect their position in the company. I will say these are the important resolutions which just does not require the approval of the majority of the members either in the meeting of the board of directors or in the meeting of the members. In addition to that, I say affirmative vote from the person representing promoters or affirmative vote from the persons representing the investors group will be necessary. They are called reserved matters. This is called supermajority. We have seen special majority. Special majority is required in case of special resolution. That means 50% in number representing 75% of the value. Whereas in case of ordinary resolution, it is only 50% in number. That is what we are going to see. But this supermajority is one of the important tool which is available within the articles of association amendments can be brought in so that hostile takeover should not happen. So let me sum up. Hostile takeover should be prevented. To ensure that hostile takeovers are prevented, within your constitutional documents also you can include the amendments called shark repellents, as well as we have SEBI substantial acquisition of shares and takeover regulations and Companies Act 2013 provisions, which will take care so that the objective is the company should be protected from hostile takeovers. If you need more about, if you want to learn more about this particular subject on corporate restructuring law and insolvency, please fill up the Google form which is being given in the description box below, and you can even subscribe to our or you watch our Telegram channel, and then for more details you can visit our Excel Academy website. If you have any questions, please comment below. We will be able to answer your questions. If you like this video, please share to your friends and then comment and then press the like button. If you need anything else in this particular topics as well as the subject from the corporate restructuring law and insolvency, please feel free to write to us. We will be able to assist you. Thank you.